Good afternoon. Welcome and thank you for joining us for today's webinar titled The Eye of the Storm, Insight into Named Storm Insurance Issues for Community Associations. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Warden Smith, and I'll be your moderator this afternoon. Before we begin, I do have a few housekeeping items. We're going to utilize PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both our videos and slides at the same time. If you don't currently see the title slide for the presentation in my video, you may need to make one adjustment to your view settings. To do so, find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose Side-by-Side mode. The slide deck should appear on the left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Our speakers today are also happy to take questions. If you have a question, please type it in the Q&A box and it will be addressed during or at the conclusion of the presentation. Now I'll turn the mic over to Alan Trask and we can begin.
Well, hello everyone and welcome. We are thrilled to have you with us today. My name is Alan Trask and I'm the co-chair of Warden Smith's Community Associations Practice Group. We've got several attorneys who are devoted to these issues that we all face in the community associations world. And one of them, if not one of the most complicated and pressing that we deal with here in North Carolina, are named storms and storms of significance and the impact they have on our communities. So that impact is terribly complicated, and we would be here for weeks if we were to try to untangle the entire Gordian knot of those issues. But instead, with the time that we've got today, what we'd like to do is touch on some general aspects of storm impacting coverage, go through some common claims pitfalls that we have noticed over the years and some experience that we've learned from, and talk through some proactive planning tips and some things that we can all do to better position ourselves for if, God forbid, another named storm comes through and causes damage. So on the call today, I'd like to introduce everybody. From Warden Smith, you've got me, Alan Trask, and you've also got Amy Wooten. We're both litigators here at the firm. We've both been in the practice for more than a decade, and we both deal with casualty claims, complex litigation issues, and especially community association litigation issues. We've both been involved in these types of unfortunate claims over the years and are very excited about sharing our experience there. I'm also extremely excited to introduce Jeff Major and Jade Bentz, who are with Skyline Public Adjusters. Jade is the Vice President of Claims and the Chief Operating Officer, and Jeff's the President and CEO. So Jeff and Jade are dear friends of ours, and they are also clients, and we are thrilled to have them with us today. The Skyline, if you're not familiar with it, is one of the best public adjusting outfits, consulting outfits that I have seen in this area. Jeff and Jade have got a combined more than 40 years of experience adjusting claims and advocating for community associations, particularly in the area of storm damage and impact on our condominiums. Oftentimes we see that at the beach, but our condominiums and our planned communities, they have dealt with claims that stretch into the double and triple digit millions, and they've been qualified as experts by courts across the country. And so we are just tickled to have them here with us today and to benefit from their experience. And so Jeff and Jay, thank you so much for being here with us. So talking about named storms, I mean, we all kind of know what they are. I'm 37 years old, born and raised in Wilmington, and have lived here most of my life. Found some statistics that North Carolina, since just in my lifetime, has been hit by approximately 120 named storms, and that has caused somewhere around $10 billion in damage. A lot of that has happened in the last 20 or 30 years. Since 2000, we've been hit by 7 hurricanes, and it looks like we're kind of settling into a pace of about every 1.5 to 2 years. We're dealing with a named storm of hurricane strength hitting us. And so when that happens, these storms have a way of completely upending the way we live and the way we do business. And so we're hoping that today we can kind of help leverage some of those past experiences to help us plan out for the future. And Jeff, I'll let you jump in on this.
Sure. Alan had given some local storm information. I'm going to give you some national and global. There were in 2020 there were 31 named storms in the Atlantic. These are those. That does not include 21 named storms in the Gulf and Pacific, and 19 named winter storms. So the frequency is increasing, and then we hope that we'll give you a little more definition of storms, named storms, and how they relate to you.
And this just is a reminder of just how bad things can be. This is from Florence, which is our sort of most recent major storm. I know Dorian was tough as well, and Isaias, but Florence stands out as one of the worst storms of my lifetime, certainly, and kind of a good lesson for us all as to why we ought to try to get out ahead of these things and make sure that we've got a plan in place before we have to deal with them. So in these presentations, I'm fond of kind of laying out roadmaps, and that's exactly what this slide is. So the things that we're going to go through in the time that we have are, we're going to tell you a little bit about storm casualty insurance generally. We're going to go through some specific common claims management pitfalls that associations can find themselves in. We're going to wrap up with sort of proactive claims management plans. What do you need to do to get, what steps do you need to take? What are the things that you need to do to get a plan in place so that when these storms hit, you're ready to hit the ground running and rock on forward? So, property casualty insurance, when we're talking about storm coverage, is just insurance that protects against damage to your property that's caused by storms. Because these storms are so impactful, they often have sort of a unique treatment in the policies and a dedicated treatment in the policies. Part of that is simply the text of the policy, but there are also some legal authorities that are in play that we need to talk through, and we'll do that. We'll go over the legal coverage requirements for condo associations and single family associations. We'll talk about the different types of insurance that you're liable to see. We want to spend some time talking about the contractual relationships between all the various parties that participate in sort of recovering from named storm impact. And then we're also going to go through some specifics on deductibles, because deductibles are often a point of serious confusion.
And I'm going to touch on this afternoon briefly the legal insurance requirements that Alan made reference to. And there's really 3 statutes that come into play here, and which statute depends on the type of community association you're talking about. For condominiums that were created before October 1st, 1986, generally what the requirement is going to be is set by the governing documents or a request of the majority of unit owners for that particular association. And that is set out in Chapter 47A of our general statutes. For condominiums that are created after October 1st, 1986, as well as homeowners associations, the 2 statutes that apply in that context are very similar. And those associations are required to maintain, to the extent that it's available, property insurance on the common elements in those associations. They're to do that to a particular value that's set in the statutes, And what they provide for is that the associations have to carry insurance that's valued at least 80% of the replacement cost of the insured property. And that value is measured at the time that the insurance is purchased and at each renewal date after you apply the deductibles under the policy. So in practical terms, what that means is that the association should know the value of the insurable property at each renewal date to ensure that it's meeting that 80% threshold that's set out in the statutes. It is important to keep in mind that these statutes set the floor for the association and not the ceiling. And these statutes expressly allow the declaration to require an association to carry other insurance that's above the threshold set here. And of course, these statutes do not prevent associations from allowing an owner to obtain insurance for their own benefit that's separate and apart from whatever insurance the association may provide. In the case of a condominium community, the statute does have an additional provision that would not be applicable in the homeowner's context, and that is for units that have horizontal boundaries that are described in their declaration. Those condominium associations are also required to carry insurance on the units themselves, but they're not required to cover homeowner upgrades or betterments that are installed by the unit owners. You can really think about the insurance here in this context as sort of being on a sliding scale of coverage, and single family homes tend to fall on the low end of the coverage scale, as coverage is typically limited to the common elements like a pool or a clubhouse. And then on the other end of the scale, you have condominium communities where the association could have a range of coverage from just the common elements to all-in coverage. Typically, what we see in this space is coverage to some extent beyond the common elements, and it's not unusual to see all-in coverage up to a certain limit. I'll touch on that in just a second. And then in the middle, and somewhat more complicated, is what you do with townhomes. Since those are owned by individual unit owners, including their exterior and party walls, they're really more like single family homes in terms of ownership than they are a condominium unit. And so what we tend to see in this space is associations securing property insurance as if they were insuring condominiums, though they're not required by the statute to cover anything other than the common areas. And of course, as with most things in the community association space, your starting point really should be the governing documents to see if there are requirements above and beyond what the applicable statutes may require. I mentioned a moment ago something called all-in coverage, and just wanted to spend a moment outlining the different levels of coverage that come up. Again, this is primarily in the context of condominium associations, but all-in coverage encompasses coverage for the exteriors of the units, their interiors, and owner upgrades. Typically, we see that to a certain level. So for example, the association may opt to get all-in coverage up to a value of $25,000 for owner upgrades versus an unlimited amount. We don't typically see an unlimited level purchased in that particular space. Walls-in coverage is a bit of a step down from all-in. Typically, what is encompassed there is coverage for the exteriors and the interiors that would restore the unit's interior to its original condition and would not cover owner upgrades or betterments. And then walls out coverage, you may hear that term from time to time. That's essentially limited to coverage for the exteriors of the unit itself. Again, in deciphering what level of coverage you may have, it's important to look at the governing documents and what they specify regarding the level of coverage that the association is going to purchase. And then a complementary type of insurance that you see in associations is something called an HO6, and that is essentially an owner purchase policy. It's intended and designed to coordinate coverage with the association's policy and covers interior damage to the units, owner and betterments or upgrades, as well as personal property contents coverage. So I will turn it over to you, Alan.
Yeah, and just a quick note on that. One takeaway is that while there are some statutory requirements for what is purchased, as long as you're above those statutory requirements, there are a lot of choices. And don't just believe that you have something, know that you have something, know what you're dealing with. And if it's something different than you or your members or your client thinks that it is, that's a discussion that needs to be had, because that's not something you want to figure out when you've actually tendered a claim and gotten your response back from the carrier.
And I would just add one quick note on that. Just because what you had the year before was sufficient may not mean it's sufficient going forward. So it is important to give consideration when renewal time comes up to make sure you're comfortable with the level of insurance that you have going forward.
Yeah, and just one add-on to that, if you have an all-in policy and you've valued your units to a certain number, and unit owners are continuously making upgrades or newer kitchens or newer flooring, that counts against your values. So you want to be conscious of what it is today and not just the cost of living or the cost of gas or, market fluctuations, but actually what is there. And when you're in a claim, those things are considered when an insurance company is looking to see if you comply with values.
So, fitting for this webinar, we thought it would be good to go ahead and provide the definition of what a named storm is. By its face, it sounds like it's just a storm that has a name. But as with a lot of things, the policies themselves, define certain phrases or certain words, and it's relevant. Later we'll talk about deductibles, and this is something that's very relevant there. But this is a pretty standard policy definition of a named storm, and it's a storm system that has been identified as a tropical storm or hurricane and assigned a name by the National Hurricane Center. That is important when it comes to applying these deductibles that we'll talk about later. And then it goes on to say too, under the terms of this endorsement, a named storm begins at the time a watch or warning is issued for the area in which the affected premises are located. So I know when hurricane season comes around for all of us on the coast, we're watching it, what is it developing into? It's depression, it's just a storm, it's a little blob, and then all of a sudden it hits Florida and it's a hurricane. Well, it is important to pay attention. By the time it gets up to North Carolina or South Carolina, it's possible it could have downgraded. And even though it is a named storm, as you and I would think of it, the policy no longer would consider it something like that. And we'll talk more about that later.
So in the 31 named storms in the Atlantic in 2020, the named storms were hurricane. They were hurricanes, they were tropical storms, tropical depressions, subtropical storm. Those are the four, all of the 31 fell in those categories. So while something may not be an actual hurricane, if your policy gives you a deductible or a restriction for a named storm, a subtropical storm could change your coverage drastically. In 2012, Superstorm Sandy hit the East Coast, and there were a lot of people, everybody was watching. So we watch when it gets named, okay, it's a named storm, which affects people with named storm deductibles. But if you have a hurricane deductible of 5% or 2%, you really don't want it to change to a hurricane. And in the case of Superstorm Sandy, there were a lot of people that had hurricane deductibles that were relieved that it was not technically a hurricane. And then same with winter storms. If you have a named storm deductible, then what happens is a winter storm that has a name is technically a named storm, but then you have to go back to the policy to see if the lead-in language for the named storm deductible says a hurricane or a wind event, or, so there's some possible ambiguities in named storm and a winter storm, because some lead-in language says designated a hurricane or a named storm, related to wind.
So one thing we wanted to talk about at length was there is the crazy relationship structure of all the participants in recovery from the impact of a named storm or a significant storm. So in the middle here, you'll see the insured, that's the association. We'll focus on the association as the insured for this. The black bars are contractual relationships, and that's really important because that's the relationship that will carry along with it an obligation to do something. So you see there's a contractual relationship between the insured and the carrier. You'll also see that there's a contractual relationship between the carrier and its third-party adjuster, and then another contractual relationship between the third-party adjuster and the sub-TPA. That's really important because in North Carolina, there's no direct relationship between the insured and the adjuster, but that's a lot of times the person that, or the outfit that the insured is working with throughout the claim, the one they're going to be talking to and emailing with and explaining things to. You'll also see that the carrier, unlike the insured, does not have a contractual relationship with the repair contractor. That's really important too, because if there's a dispute between the repair contractor and the carrier, there's not an underlying contract there. And so a lot of times what can happen, and what this is gaining more and more popularity, unfortunately, is that carriers are unhappy with the repair contractor and putting pressure on the insured over that. You'll also see that the public adjuster, and we'll talk about the role of the public adjuster on behalf of the insured, they have a contractual relationship with the insured, not with the carrier, certainly, and also not with the repair contractor. And the reason we spell all this out is because when disputes arise, it's really important to understand the underlying nature of the relationship, because if you want to enforce an obligation, you are limited if you do not have a contract. And so this slide tries to encapsulate sort of how complex it can get. And note that the remediation contractors are not on here, and other parties that that would participate in this endeavor. If you have auditors get involved, all that sort of thing, this picture can get even more complicated. The last lesson from this picture is that we're going to come back to this in the proactive planning portion. But when you're structuring your plan and when you're thinking about what is your go plan, this helps inform how you set that up. And so definitely do keep this in mind.
So one of the items, like Alan just alluded to, we're going to talk about later is, your pre-planning and how does everything work together. Something that we found that's really important is, understanding your insurance policy and your obligations before having some catastrophic event. Unfortunately, that's typically when folks look in depth at their policy is, during the event or after it's already happened, but it's important to kind of understand your obligations, particularly as an HOA and, boards that are making decisions for groups. What your financial obligations will be. So, there's a various types of deductibles, and these are just some of the main ones that are relevant for this. You have a hurricane deductible where it's officially designated, and that's, the first three here are typically percentages. Then you have a named storm deductible, which we talked about is a hurricane or a tropical storm. And then you'll also have wind deductibles, which are typically wind and hail deductibles. I know we don't face that as much on the coast. That's also a percentage of your policy limit, of your building limits. We do see something from time to time that you should be aware of. A lot of times, either it's just the carrier's preference, or if you have a history of a lot of interior plumbing losses and water damage, the carriers will impose a per unit water damage deductible that may be higher than your standard deductible, or may mean multiple deductibles, resulting from one loss. So these are just all things that you should be aware of. Typically, these wind deductibles are a large financial responsibility to the unit owners, because that cost is typically passed along via an assessment or something like that. And I know we're not really getting into HO6s here, but we found in our experience that it would be our recommendation that the board at least notify your unit owners that their loss assessment coverage on their HO6 policy should cover the pro rata share of that hurricane or that wind deductible at a minimum, to help offset costs during a catastrophe that can be reimbursed. And then this is just, we're just going to show you a couple of policy examples if you guys are looking through your policies, kind of trying to understand where to look. This one in particular is, we've got a deductible percentage of 1%. You see there in the upper right, left of the box. But we wanted to include this for the note that some policies might have a percentage deductible, but they actually have a minimum deductible per, say, building, or per something like that. So it's just important to, it'll be kind of a running theme when we're talking about some of this, to kind of know what your policy has and what that'll be.
If we can just go back 2 slides. One more. Perfect. So in this example, this policy actually has a deductible schedule. And they have 8 different deductibles, and number 6 is by wind, hail, or hurricane. If you look to the right in the small box, it says per deductible schedule. So while you have a schedule of the deductibles, there's a separate deductible schedule, which is on the next slide. And you can see on the top box, on where it says C6, which is the coverage 6, wind, hurricane, and hail, they're excluding coverage here. On the other location on the bottom box, they're doing a $25,000 deductible. So this policy has a schedule of deductibles, a deductible schedule, then a further schedule that defines the deductible for each one of those coverages. And in this case, on the one policy, they actually exclude coverage in the deductible section.
Jeff, if I could just add here, I think this is a good time to pause and for us to all remember that these insurance policies are not just policies, they're contracts, and they're binding legal documents. And the presumption under North Carolina law is that the parties entering into the contract have read to it, and by agreeing the contract have agreed to and will be bound by its terms. So it is important as you're reviewing your policy to ensure that you understand its contents, and if there are questions about what is or is not included, talk with your agents, talk with your legal counsel, and find out what you're actually purchasing before you commit yourself to the coverage.
And make sure you get, if you're going to ask a complicated question of your broker about, a coverage or something like that, make sure they give you that answer in writing. Just send them an email, because these policies, like Amy mentioned, are very complicated. They're just, unless you read them every day, they're complicated. They don't make sense, and there's no Rosetta Stone for them. So if you're going to rely on your, attorneys or your insurance agents to answer these types of complicated questions that come up, just make sure they do it in writing. In that way, if there is a mistake, at least you have something to go back on with respect to that piece of advice.
So Jade, are you taking this, or do you want me?
Yeah, we can So we just wanted to give you guys a quick overview. We just talked about deductibles, but there's some other specific, pitfalls that we've experienced, that plague associations after a catastrophe. So we just wanted to touch on some of those. So the first one is coinsurance, and we won't get too much into the weeds on this, but just want to, again, what we were talking about, knowing what to look for in your policy and when to ask questions. So most of the policies that you guys are going to have, would be a replacement cost policy. But there's typically conditions, and that is either that you have a coinsurance condition or you have agreed value. In the case that you have agreed value, you typically don't need to worry about coinsurance. But in the event that you have a coinsurance provision, it basically, and there's an example here where this particular building is, insured for $2 million at replacement cost, the RCV there, with special coverages and an 80% coinsurance. So what that means is it's basically requiring you to have your buildings insured to value. And so the 2 million, and Jeff's going to give an example in a second, but the 2 million needs to be equivalent or greater than 80% of the replacement cost of your structure. And then you see down here, this is a common policy language that states, if you're not complying with that condition, they will not pay the full amount of any loss. And I think the example will help clarify some of this.
So I'm going to oversimplify coinsurance, but it's fairly complicated, and we deal with it almost every day. The simplest explanation of it is if the value of your structure, of your building, is $1 million, 80% of the $1 million is $800,000. So if you're carrying $800,000 worth of insurance or higher, then your claim is paid on a normal, way that they adjust the claim. If you have $500,000 worth of damage, you get $500,000. If you're not carrying 80%, for example, if you're carrying, instead of $800,000, $600,000, then the value against what your obligation is 75%. So what'll happen is because you're only carrying 75% of your obligation, the insurance company will only pay you 75% of your claim. So they'll impose a penalty of 25%. And if your damage is, in the example of $500,000, if you're carrying $800,000 worth of insurance, you get your $500,000. But if you only have $600,000 worth of coverage, you're getting $375,000 on your $500,000 claim. So it's important that not necessarily you figuring the calculation out, but by making sure you're compliant with carrying whatever your policy is. And in some cases on the coast, a lot of insurance companies are not writing certain policies, and you have to go to non-admitted carriers or other insurance companies, and a lot of them will only issue coinsurance policies. And if that's the case, it's the single most important thing to do to make sure that you're not going to be penalized. And the other decisions you make on having a certain deductible and other types of coverages are decisions that you control. And this is one that you can't fix the penalty. You can't choose. You're going to get a penalty if you're not carrying the right amount, and you want to make sure you're good there.
Thank you, Jeff. And before we move on, we did have a question come in that I thought would be great to address during this portion of the program. So the question is, what do you feel is the best way to determine replacement cost value? Should the carrier help determine an accurate replacement cost?
So it's a little bit of a loaded question. So the carrier can, what we find is most carriers do not want to make that recommendation, or they don't really participate in that calculation because they're leaving you to determine how much insurance you want. And I think what we've found in adjusting claims where we've had claims where the insured and the agent or broker decided it should be around this much, and it turned out it wasn't the case. And so what wound up happening was the insured was saying, well, you helped me with the number, and the insurance company said, well, we had nothing to do with that. So what you should do is you can talk to builders, you can talk to developers in the area, real estate developers, real estate brokers, and builders. So a lot of times, I know there's a couple local management companies where they will help gather the costs to replace. Now, it's important that in the calculating of your replacement cost that you also define what is insured and what's not insured, and you clarify that. Now, Alan said to make sure you do that type of stuff in writing. So, for example, if you are an all-in policy, then you need to calculate everything. If you're a walls out or a studs out policy, you should clarify whether you're required to carry 80% of the value to build the structure or 80% of what you're insured for. I believe it's the former, but so what you can do is there's some basics, there's some rules of thumb, and there's also companies and people out there that will get values. There's industry standards, $200 and some a square foot for a certain type of construction, and there's guidelines. So if you're looking for that resource, we can help guide you or give you some rules of thumb. And there are Marshall Swift Beck. There's a bunch of valuation services that are online that can help guide you also.
And Jeff, do you mind just repeating the portion that you said about declared value?
So let's just say you're a condominium association, and all you insure are the framing and the exterior of the building. So the roof, the framing, the doors and windows, the common areas, the pool house, the restaurant, all those things would be like in a studs out policy. That's what you would be able to collect on if you had a fire, if you had a storm. You couldn't collect on in a studs out policy. You couldn't collect on a unit owner's if your policy, if your bylaws define you not owning it, you can't collect on your unit owner's vanity. So if you're only insuring the exterior items and what your bylaws say you need to insure, you would say to the insurance company, or let's say that value is $100 a square foot, then you would insure for at least 80% of $100 a square foot times your square footage. If you're an all-in policy, or if your policy for a studs out coverage requires you to insure 80% of the full replacement cost, then you have to consider all those other items. You may be at $230 or $240 a square foot. So it's you're basically, you want to identify, and we'll talk a little later about your lab work, you want to identify what your insurable interest is, and then clarify with your agent or broker what they want the value, what they want you to comply of this 70, 80, 90% value to, whether it's just your insured items or the whole, and then you can do the calculation off of that. So that's sort of not exactly answer your question, but it's the proper answer, technically.
Thank you so much, Jeff. I will we'll keep addressing questions throughout, but I'll turn things back over and we can pick back up with flood insurance.
Yep. And then just real quick, we'll give you guys, we'll get in the follow-up seminar, we'll get you a Microsoft Excel co-insurance calculator that you can mess around with and plug in numbers, and if you need any help, reach out to us.
So following that that theme of co-insurance, we just wanted to touch on flood insurance, since you know, a lot of your coastal associations and even some inland, depending on where you are required to carry that. As you guys may or may not know, you can typically have some type of carrier such as a Lloyd's of London for your flood insurance, in which case the co-insurance is similar to what we were just talking about. If you have flood insurance through FEMA, through the NFIP, your association should be on, they only have one of three options through the NFIP. And so residential and most of your commercial associations, or I'm sorry, residential with some commercial, would be on what's called an RCBAT, which is a residential condominium building association policy. And that is really, there's not an option of having agreed value or 90%, 80%, 100%. The policy itself actually dictates, you know, what you have to have, and that is a minimum 80%. Or a maximum of 250 per unit. So if you have, you know, 10 units, it's 2.5 million. And it is the lesser of those two, but it's the form itself, and that type of coverage comes along with its own restrictions, but they are very strict on their co-insurance. So it's important that if you're under an NFIP policy, that you are insured to that 80% or that 250 a unit. And here's just some of the language here.
You can note on that last slide that they give the policy actually gives examples, and most of your policies, if you have a co-insurance policy, you can look and there will be a section that says co-insurance, and you'll read it 3 or 4 times before it starts making sense. But it'll actually give you examples of what you're insured to. And if you're looking at an RCBAT, which is Residential Condominium Building Association policy through the FEMA, through the federal program, just note that when they say to you, they give you an example, they tell you you need a minimum of 250,000 per unit or 80%. Then in their example, they use 250,000, and then it says required amount of insurance is 200,000. It's slightly misleading, and some people have been confused by that. It does not mean that you need to carry a minimum of 80% of 250,000 per unit. It's either or, and I think that they're talking about changing the example to 500,000 to not potentially mislead anybody.
And before we move on from this slide, I just wanted to add a little additional information from the legal side of things. So many provisions in an insurance policy can be subject to interpretation. You may have some ambiguity arguments that allows for a little wiggle room to negotiate with the carrier. The language that you're seeing here is taken from a statute, a federal statute that applies, and it reads the way it does, it applies the way it does, and most of the litigation surrounding this has been fairly well defined at this point. So there's not a lot of wiggle room when it comes to this particular type of a policy provision, and just very helpful to keep that in mind and to pay close attention to these co-insurance provisions, because they do have substantial impact on the coverage available.
When we're talking about common policy pitfalls, co-insurance is a tremendous one across the United States and everywhere. Wind-driven rain is really unique to the coastline and the Gulf, basically coastlines and storm areas. So they've identified, insurance companies sort of say, hey, we have a lot of wind-driven rain losses here. We're gonna put some endorsements in our policy, or possibly offer sublimits. It's important to know you can purchase different sublimits. You can not have a sublimit on wind-driven rain, and if you talk to your agent, you'll see that the dollar amounts they're pretty extreme. So there are certain companies who will only write insurance with a, let's say, $1 million or a $2 million sublimit or a certain sublimit. And then there's other companies that will allow you to alter the wind-driven rain sublimit. It affects your premium. So, but it's important for you guys to understand how impactful it is and try to avoid that pitfall. So wind-driven rain is, as it relates to the policy, is interior water damage that comes through doors, windows, or other openings that are not created by wind or hail. That's the way the policy reads. In some policies, they actually exclude wind-driven rain, period, unless you endorse it. And then most of the time when you endorse it, you're going to get a percentage or you're going to get a dollar amount. So it's very common to have a wind-driven rain sublimit, but it's important to know the potential costs. So if you're carrying if you're carrying a $1 million wind-driven rain sublimit, you could potentially have and if your building is big enough, you could have $1 million remediation, emergency service, and dry out invoice and have no money left in the policy for repairing your wind-driven rain damage. In a lot of times you could, we have a client that had a $500,000 wind-driven rain, or they had a $500,000 deductible, and they had a buyback policy. If you go to the next slide, it's the buyback policy language. So they had a wind deductible buyback, so they were able to get their deductible reduced to $25,000. However, that wind buyback policy, and this is a North Carolina policy, the language was losses caused by wind-driven rain or wind-driven precipitation are excluded. So you have different languages that will either give you you have to sort of look at both your deductible and your coverages. In some cases, if you're going to rely on the buyback policy that reduces your deductible to afford wind-driven rain coverage for you, a lot of those buyback policies exclude it. So you want to make sure you're mindful of your wind, your deductible or your storm deductible, but also your wind-driven rain language. On the next slide is a wind-driven precipitation endorsement, and it gives a limit of wind-driven precipitation. And this says when driven by wind, absent any damage to the building or structure. The other language before was, there's multiple variations of the language. Some policies say that, there first has to be an opening caused by wind. And then probably for maybe 6 or 7 years, when they had shingles that blew up and wind-driven rain went under the shingle, that was technically an opening caused by wind. And insurance companies were initially denying those coverages. Through litigation, they started having to pay those coverages. And then they changed the policy to say that it has to be a permanent opening caused by wind. So the language is important, and it's important to know, but in a lot of the newer policies and the most common policies, it defines that there has to be an opening, a permanent opening, a break, or it actually defines it. So you want to read. It's one of those checklists when you're doing your lab work, which we'll talk about in a little bit, to check to make sure you know what your coverage is. So when you have a wind-driven rain a sublimit, or you have coverages and you have a claim, it's important that when you're recovering or you're addressing your losses, and in the next slide I have a sample. This is a sample of it's actually, I'm using as a sample, it's actually a unit that was moisture mapped by a certified industrial hygienist. And what they did is, in all these locations in the unit, they identified the amount of water, that the ceiling had to come out or make a 2-foot flood cut. So they identified all these things. But in this condominium, after a loss, they had a wind-driven rain deductible. So it was important to bifurcate the damages that were caused by openings and the damages caused by just water that came in through the windows from the pressure of wind-driven rain. And I had said earlier when I said that we go through and we take pictures, that's the reason why you identify all of the openings caused by wind, so you can differentiate between the two if you have that sublimit. On the next slide, this is a condominium, and you can hit the next one, which I zoom in. These are all holes and tears in the roof that were identified, that we marked up to make sure we identified the non-wind-driven rain damage from the hurricane damage, from the wind damage. And then the next slide is this is an insurance company, consulting company, where they map, in this example, there's a bunch of pipe breaks. There's 5 pipe breaks, and they identify the damage to the floors, the walls, the doors, the ceilings from each individual break. And there was a reason for that. I don't know what the reason was, but this is using today's technology, so you can differentiate, providing that you actually differentiate. So you have to be mindful of what your coverages are, and we'll go into it a little later on what you should discuss with your remediation contractors and your vendors post-loss. So you don't have, let's just say you have a $2 million wind-driven rain deductible and you have $10 million worth of damage. You don't want somebody to just say, oh, it's all wind-driven rain, when 7 of it could be, wind damage, and 3 could be wind-driven rain, and you have $1 million uninsured loss. But it's, as opposed to having more of it dumped into a category inappropriately. So you want to make sure that you have, you're able to bifurcate the differences.
So the wind-driven rain, as Jeff said, I mean, that's a major sublimit and or exclusion that we see a lot of folks face, but there are a few others that we wanted to mention. I think this goes without saying, but as you guys probably know, the policies contain, multiple types of sublimits and restrictions and exclusions, but we just wanted to list a few that are, relevant to catastrophic, hurricane or storm losses. And one of them is mold. And I think everybody says, don't say that word. You don't want to, go out and be saying there's mold all over my apartment, particularly, or unit, particularly after a loss, because a lot of the insurance policies a few years ago, they put in very specific language where they will give some type of coverage for mold. But even on a massive association, where you're talking about multi-millions, we've seen it where they only have a $15,000 aggregate mold limit. So for the entire policy year. But this is where we always try to, inform folks. And, Jeff was talking about identifying where the damage is coming from. It's important to identify, is that sheetrock moldy because it's wet and it's, it's on the ceiling where the roof's been leaking after the storm, and is it coming out anyway? So it's important to notate that, and we'll talk a little bit later about your obligations, but in your claim presentation to the carrier, you want to make sure you're separating out what's truly mold and what's just wet, that's Cat 2 or Cat 3 drywall that would be coming out anyway. And then one of the other ones that we see a lot of is, ordinance and law, again, similar to wind-driven rain, unless you're endorsing ordinance and law, which is code upgrade coverage, unless you're endorsing that on your policy, it's going to be excluded typically. You may have a small $10,000 sublimit. Some of the policies just give that, but otherwise, you're not going to have any coverage. And we've actually run into a lot of claims where the associations are older associations, which means it's pretty likely that you're going to have, some type of code upgrade requirements if you have a loss. And I think they even changed requirements following Florence a couple of years ago for some of the building codes. So this is something else you want to talk to your agent or broker about and see if you've got this on your policy. If you don't, as a board or as a management company, you probably want to explore what's the cost of getting that added to our policy. And it has its own nuances attached to it. Doesn't mean it just covers anything and everything that needs to be upgraded. Sometimes there is a misconception that so one of the things it doesn't extend to is, if you had a code violation pre-loss, like let's just say, I don't even know how to give you an example, but your HVAC unit was changed out, but they didn't change the breakers that they were supposed to, or something like that, and that was pre-loss, and it wasn't done to code. Post-loss, if there's an additional cost there, that's not something where it would extend coverage, but your other code requirements that just come with time, would typically be covered if you had this ordinance and law endorsed.
And we see this all the time with beach condominiums. It affects any insured that we're talking about today. But I would say, practically speaking, if you are a beach condominium, you should definitely pay attention to this. See it all the time with handrails, handrail heights. What we're talking about is your existing structure gets damaged or needs to be replaced. And the replacement is going to be more expensive than what was there to begin with, because now the code's requiring some sort of a new handrail or new stairwell or something like that. And so sometimes it doesn't make a difference because the code can make things cheaper. Or by the time you're actually replacing it, it kind of washes out. But it is worth looking at and worth getting coverage for it. And just remember, insurance policies are just a contract, and if something's not in there, you can often buy it into the policy. You can often talk to the carrier about what endorsements are available. It's a negotiation like anything else. These things aren't just necessarily prepackaged. Pick door A, B, or C. A lot of times you can customize them to your own needs.
Exactly. And then just the only other thing we wanted to mention quickly is a lot of the, if you have larger associations, you may have what's considered layered insurance policies. And this isn't really a supplement or exclusion. This is just more something that you should be looking out for. And this is where, if you have a $20 million condo, you might have 5 million with one carrier, 10 million with another, and another 5. And what we found, though, is that although the language between those layers are similar, they're all independent policies, and they may tie to one another. There may be some reference to the other one, but sometimes their policy conditions and your responsibilities as an insured vary across those different levels of insurance. And just to give you an example, just quickly, there's a policy requirement or condition. I think it might be listed on the next slide for giving a proof of loss. And we just did an excerpt here for duties in the event of a loss. And actually, it's not there, but it's under this section. And, it might require a proof of loss only be presented to the carrier upon their request. But then that upper layer of insurance, which you may or may not tap into if you've had a catastrophic loss, that might say that they don't even need to request one. The policy itself, the contract that you've entered into, is stating that you need to provide one within 60 or 90 days from the date of loss. And, where this comes into play, is if when it gets to Amy and Alan, and the first thing they need to look at, because that's what opposing counsel is going to look at, is, did you comply with policy conditions? So it's just, again, something else to be cognizant of. And then just the one thing to go into the next is, there's some duties regarding, for you protecting the property from further damage and mitigating your loss. But at the same time, you want to preserve the evidence and keep the carrier notified if you have had a claim, so that you can avoid issues down the road. And
Right.
Jeff,
And the rule of thumb is you're darned if you do and you're darned if you don't. So if you preserve the evidence and you don't do the remediation, you're going to grow mold, which you're not covered for. If you tear it out because it's water damage, then the carrier didn't see it, then you didn't let them see it. So, we'll keep in mind, we're packing like an entire 4-day multi-session information for you guys into an hour. So I'll run through a couple things quickly. So that on the next slide, so we're going to discuss, to that point of doing remediation, is you want to make sure that you know ahead of time, if you can, who your remediation contractor is going to be. You should know what your responsibilities are, what your coverages are, and then if you're going to have, let's say, a remediation company, and the next slide's a ServPro, if you're going to pre-sign a contract with a remediation contractor, you want their rate sheet, and you want to give their rate sheet to your insurance company, and you want them to know ahead of time, and you want to find out from your remediation contractor, are you using local contractors, or are you bringing people in that we are paying a per diem to? Because your insurance company should know that. But equally as important, you want to be able to have the agreement with your remediation company that they separate the costs for the things that are and aren't covered, so you can identify them and claim them properly. So you're addressing all these issues. We call your lab work. I put adjuster in, but it was really your lawyer, your accountant, and your broker. Sort of throwing adjuster in there because I think that adjusters should be involved in the conversation. But you have a legal obligation, which Amy and Alan will discuss, on as a fiduciary if you're a board, or as a fiduciary if you're a management company. But you want to know what's in your policy. You want to have a discussion with your lawyer to know your obligation, and then you want to have a discussion with your broker, and in a case of a business, your accountant, but in the case of a condo, your adjuster, to help you sort of look at your coverage, to say, here's the things you should consider, and do you know you're covered for this, or what your limitations are.
So we've kind of come to the place where we need to talk about the upcoming season and getting a proactive plan in place. There's no reason to wait. Frankly, these situations are so grave that even if you go 5 years without a storm hitting, which would be great given the last several years, you want to have a plan in place. And even if it's not a plan that you are going to utilize while you're representing a community or on the board of the community, having them set up for success is a good thing. If you're a board member and you're a unit owner, say you roll off the board, you want to know that the board that's going to be in place in 2 years when you're off is going to have a good plan to work off of. So think about, put yourself in the situation. The storm has hit. What are the things that you're going to need to do? You're going to need to get on the phone with, if you've done nothing else, you're going to need to get on the phone with a mitigation contractor, somebody to get in there and dry it out. You're going to need to get on the phone with a repair contractor to actually get out there, start valuing the job, help you get ready to start construction. It is so much better to have established those relationships with an attorney, your adjuster, and a good broker, good attorney, good adjuster, good broker, a good reputable contractor, and a good reputable mitigation company beforehand, long before you get to the place where you actually need to call on those folks. A couple reasons for this. One, when you're calling people at the last minute, you don't have time to negotiate a deal. You don't have time to negotiate a contract. You don't have time to talk to them about what it's going to look like when they get to work what their role is going to be, what they're going to do for you, how they're going to do that for you, all of that sort of thing. The second thing is that if you can get in the door ahead of time, then you can get ostensibly first crack at that particular vendor before everyone else loads up on them. We had a horrible shortage of mitigation specialists and repair contractors. Folks went weeks and weeks and weeks without being able to find one until more got shipped in from across the country. And so the folks who got out ahead of it, who were experienced, ready to go, were in such a much better position than the ones that had to run. Now, look, this is a hindsight is 2020 thing. And no one should be criticized for finding themselves in the situation that I just described, because almost all of us found ourselves in that situation, either personally or through service to our boards. What we're talking about is not criticizing that, but instead learning from the past and better positioning ourselves for the future. I'll give you a good example of that. Our firm kind of took those host of experiences, came together and realized, gosh, we're seeing tons of folks with pretty rough contracts with their repair contractor. Why don't we come together, prepare at least a baseline contract that our association clients can use with their contractor ahead of time, if nothing else, as a starting point. And so we've prepared that product and we've kind of rolled that out, and we're getting our folks out ahead of it. And I would encourage you all to get out ahead of it too. I'll let Jeff and Jade speak a little bit more to tendering the claim and staying on your carrier and managing the carrier throughout the process. But I would tell you that you need to be prepared to move as quickly as possible once the storm hits, because everybody's going to be doing the same thing.
Yeah, there's in Florence was a great example. There was a shortage. People were coming in from other parts of the country, and then Michael hit in Florida, and everybody sort of made a right and headed to Florida. So if you were in the North Carolina coast, there all of a sudden all these tarp and roof signs showed up on every corner everywhere, and then literally a week later they were all gone and everybody was gone, and there was a shortage and there was nobody around. But claim wise, it's important. The most important thing is, once you've identified your coverages or your buckets, is to have any vendor you bring in or any work you do be categorized before it's happening, while it's happening, and for the invoicing to be categorized into those buckets. Photographs are unbelievably important, and for condo associations or management companies to have some type of Google Drive or some type of drive or location that people could upload their photos is always a big help. We were at a condo that has disputes with their insurance company 2 years ago, and one of the unit owners said, "Oh, I have a video of the water pouring in." So that was able to resolve one of the issues in that matter. So then keeping a clear timeline of what happens in communications is very important. And the rest of it is, do you have somebody presenting your claim? Are you identifying the way the insurance company wants to have it presented, and is your contractor putting it in that form? Sometimes insurance restoration contractors do know what insurance companies want and need, and they document their work that way. Non-insurance contractors or restoration contractors are not familiar with insurance work. They just tell you, hey, I'm charging you this much a room or a unit to paint, while the insurance company is looking for a square foot price on the walls, linear foot on other things. So you want to try to identify any of those misunderstandings or gaps that you want to bridge, and then make sure that your claim is going down the best path in communication as possible. So that's sort of your post. And I think the biggest thing is if you identify your coverages ahead of time and don't have those shortfalls, and then you identify all your expenses into the proper buckets, it's going to give you your best chance of understanding avoiding misunderstanding and recovery.
And remember too, guys, your adjusters, your lawyers, to some extent your brokers, these are all people who are your advocates, and who are going to work on your behalf to make sure that you're being treated fairly and you're getting the most value out of your contracts. Your carrier and your repair contractor and your mitigation contractor are different. Those are contract vendors. And at least in the case of the carrier, they may have interests adverse to you in terms of how you value the claim, because they've got a business interest in valuing it as, accurately, but fair to them. And then your repair contractor and your mitigation specialist, they're there to do work for you, but they're not necessarily there to advocate on your behalf. Now, sometimes we see contractors kind of working with insurance companies and that sort of thing. But I think it's really important to make that distinction as you think about how you structure your relationships ahead of time.
Great. Well, thanks everyone. And for those in attendance, we have run over our hour mark a bit, but all of our presenters have agreed to stay on to answer the pre-submitted questions and the live questions we received. So if time allows, please stay with us. And with that, I'm just going to jump right in. So I will pose the question and y'all just, anyone chime in with their response. So the first question is a pre-submitted question. And the question is, what can we do to find good insurance for our older small properties to save them money, especially the ones that have never filed a claim for storm damage?
So I'll do a quick stab. I've been doing insurance claims for 29 years. I believe, and I think Jade may agree, that the consideration of never having filed a claim before is gone. I don't think that the relationship, there used to be, when I grew up, there was Rich Denikin was my dad's agent, my grandmother's agent. He said Denikin State Farm on my soccer uniform. And, he showed up to my house one day and I said, "Hey coach, my dad's not here." He says, "I'm not here for him. You're getting your permit in 3 months." So we had a relationship with our agent. He knew our family, he had everybody we have, and that's just where we went for insurance. And right now, while having losses does affect your premiums, I don't believe you get a discount for not having losses. It's here's your price for not having a loss, here's your price for having a loss, but it doesn't go lower. It's capped, it's something. But it does mean something to not have losses. But if you're shopping, and this is really important, and any broker can tell you, or agent can tell you, your agent can tell you, if you're shopping price, just price, it's very likely that the cheaper policy has no coverage for wind-driven rain. It has no mold coverage. It's an actual cash value, not a replacement cost policy. So you're going to get less. And if you have an older property, that if you had a loss and a fire or some type of larger loss where the township or city would make you bring it up to code, if you have that law and ordinance and law coverage, you're going to get paid to bring it up to code and not have an uninsured loss. So you want your relationship not necessarily with your insurance company, you want your relationship with your agent, your broker, and you want to understand what it is. Why is policy A more money than policy B? And if your agent says to you, well, that's because they cover wind-driven rain, it's a replacement cost policy, and that has ordinance and law, you can look at your home and say, all right, it was built in 1978 and it's not to code, and I should probably have that coverage. So I hope that answers your question. So it's really I don't think you're going to get a credit for not. You do sort of get a little penalized for having claims. It's on your loss run, but you should be mindful and look at the things we're talking about, because I think that's going to affect the cost.
Great. Thank you so much, Jeff. So the next question is, are there safety or procedures that we can put in place that can assist in reducing the cost of insurance? For example, when this person was in Florida, they had an evac plan and a plan to protect assets during a storm. And because of that, they received a discount.
So we're dealing with a broker in North Carolina right now, and he had, there was a certain insurance company that did not want to write insurance in a certain area. And because they had plans in place and remediation contractors, and they had all these emergency plans, that broker was able to convince that insurance company to write that policy, and it was at a discount. So I think it would be important to you should have it anyway, but I think you should present it to your agent or broker, because he can use it in shopping insurance. And it may be that it's to get a discount, but it also may be to get a carrier that is an admitted carrier or a better carrier that's higher rated and responds to claims better, and then one that would not want to take you. So I think there's definitely a benefit. You would want to set it up and communicate it with your agent or your broker, so they can communicate it to the insurance markets when they're shopping your policy.
Great, thank you. So another question that came in was, this attendee was asked recently by a board president if there is sewer line insurance for broken pipes or repairs.
That's a Jade question.
So typically, I think we were saying earlier, you can go to your agent or broker and kind of say, hey, I want this, what's it going to cost me? And there's usually some market out there that will, extend coverage for that at a certain premium price. Typically on a lot of the forms that we look at, particularly for HOAs, a lot of your underground piping and things like that tend to be not covered property. There are some endorsements that you can, tack on to those coverages that will extend that. But then it turns into, what is causing the break, right? Is it a maintenance failure? Is it because the line is 30 years old or something like that? Or is it because, or was there actually some type of direct casualty loss that occurred there? In that case, it would likely extend. But there's nothing I know of that's like a easy endorsement that you could purchase for an all peril.
Right. But the other thing to consider, and it's not a way around it, but it's a coverage. In a lot of policies, they don't cover underground lines, or they don't cover certain backups or certain defects of construction or failures. But there are policies that they deny those things, but they cover ensuing damage. So where that underground line may not be covered, any damage that failure caused is covered. So there are policies, and you can look at solving that riddle or that gap or concern that you have. And it may be that you're solving it in the ensuing loss coverage as opposed to the item coverage.
And I'll just say real quickly, that is something to consider. A lot of the policies are bare bones, but there are some pretty broad endorsements that you could be eligible for, that'll give you coverage back for, even your paved surfaces and things like that. So there are definitely things when it comes time for renewal, you should talk with your agent or broker about, well, what endorsements are available to us that may enhance the coverage that your association has. And then obviously all of this, as you guys know, is to try to limit, if you do have some type of loss, is try to limit what your passing along to your unit owners. I mean, it's all uninsured if it's not covered by your insurance policy. And even though condos, sort of run like a business, it's not the same financial situation that you have in a regular commercial business. It's being passed along to your membership.
Great. Thank you, Jade, and thank you, Jeff. So the next question I think will be easy to answer, and it is, can we share the information that you discussed earlier in the presentation regarding online valuation services?
Yes, we'll get you. We'll go in and see what we can find. And the reason I'm saying that is I have to see if anybody has any sort of like free version. We subscribe to services that we pay for certain things, but there's some valuation services. And I know there was another question about an index or something for increased costs because of COVID-19, and equally as important, when there's a bunch of storms, and this was it. What this year was from Ohio down to the Gulf Coast. There's massive amounts of storms, and material prices have skyrocketed. It's important to know that the replacement cost value for coinsurance purposes, you need to carry 80% of the value at the time you're insuring your property, not at the time of the loss. So if it turns out the prices go up because of market conditions during the policy period, you don't get penalized for that. But costs are going up, and if you do know the costs are going up during your renewal time, you can adjust for that. So if you're looking today to do a RCV value and you want to consider increases in costs and COVID, you should add 11%. That's sort of the right now value. If somebody tells you a year ago it was 100, you should add 11% to that now to address the current market. And I think you would be safe there.
Thank you. And then we have one more question, and it's got a little bit of information leading into the question. So regarding flood insurance, this attendee received a call from a resident who said their insurance carrier told them that FEMA requires an elevation certificate for them to get flood insurance. The carrier told them to call the HOA for assistance. Should the association be assisting them, or are they responsible for themselves? This might be a question for Alan.
I'm going to say it's a combination. It's a Jade and Alan answer. The building and the fact that it's an HOA, so the building needs a certificate. So, and then separately, so there's two things. If you're the HOA, your building coverage, you should have an elevation certificate. And it depends on the age of the building. But because units are at different levels, it would be the unit owner having their own, and Jade, correct me if I'm wrong, the unit owner having their own elevation certificate. So because you can be in unit 1A and be below grade on all four sides, or be below the base, below the lowest elevated floor above the base flood elevation. That's a whole nother weekend seminar. But unit 3B may not be. So while the association building may need it for their insurance, each unit owner may have a different level that they are. And an elevation certificate addresses your specific unit with relation to the base flood elevation and the lowest elevated floor above the base flood elevation.
And just to add, Jen, as far as I have to be honest, I'm not sure where exactly they would get one issued. I would contact the township, and they probably have a floodplain manager or something like that that would be able to come out and do that certificate if the HOA itself doesn't have one that satisfies the unit owner's insurance request.
Great, thank you, Jade. Well, that was all of the questions for today. So thank you so much to Amy, Alan, Jade, and Jeff For those of you in attendance following the webinar, I will send you an email with a recording of today's session, a PDF of the slides, and other helpful information that we discussed during the presentation. Warden Smith and Skyline Public Adjusters appreciates you taking the time to join us today. We hope you're able to take some of the information you learned and apply it to your own association. Thank you again, and that concludes today's webinar.